Hi everyone, great to be here with you today, and a fantastic kind of setup from the previous panel. Tokenisation, I think, is such an interesting topic, but it's also a topic that's kind of highly loaded in the sense that word can mean a lot of different things. And actually the practicality is where the rubber hits the road is often on the legal construct and thinking about whether it's a digitally native token, what's the intended utility of the token. And I have to say, I spent a decade in traditional markets figuring out how to make them work, and the last decade launching a layer 1 blockchain canton network, which is where I'm currently building. The prep for this panel helped me immediately in how I not only build for myself, but advise my clients. So I think we're in for a really good discussion around the practical insights. And I think there's a lot of jargons. There's a lot of different terminologies. And the reality is today, most of the market activity in tokenisation is not happening in the UK. But the good news is we're not starting from nothing. I think we had some good kind of insights in the opening discussion as well. And there is a bit of a danger that we kind of move into kind of sandbox after sandbox after sandbox in the UK instead of getting going, as good as the sandboxes have been. So, as I open up, I want to talk to Jonathan firstly about what is working well. What can we kind of learn from other markets? Where do we have some certainty to lead on?
Yeah, sure. Thank you very much. Great to be here. Great to be at the conference. Well, there's an awful lot that we in the UK can learn from other markets. We've already heard about how the EU got off the blocks quickly with MiCA. And we have learned from that what they have done well, but also what they've had to step away from and think about, okay, how will we reform that in a future MiCA 2.0? We're also looking ahead to what the US does under the Clarity and Genius Acts. Actually, though, what the UK can learn from other jurisdictions is often from those offshore centres, which have been a little bit more nimble in how they've adopted, how they've thought about the application of their existing legislative and regulatory frameworks to tokenised assets. And I think there's a lot that we're learning from those jurisdictions in order to apply a more regulated landscape in the UK to tokenised assets.
Yeah, absolutely. And I think, picking up the point around the Digital Assets Act and some of the benefits that actually brings the UK is a real plus. And I'm not sure if, Charles, you had some perspectives in and around, how we might think about applying that and what certainty that gives us in the UK.
Yeah, I'm unmiked.
Oh.
Your wish is my craft. Thank you. Okay, I was going to check you guys later. The significance of that, I think it's world-leading piece of work by Professor Sarah Green and the folks at Law Commission with lots of support from the legal industry and the crypto and TradFi industry. What's turned out to be significant is that private law analysis of the legal characterization of the token that's created by the underlying blockchain, you need to do that first before you can do the financial regulatory analysis. And I think sometimes the folks who've got a background in financial regulation jump to it's either a representation of value or it's a receipt token, because that's the framing of the MLRs. In fact, it's often something in the middle, or it depends on the functionality that you apply or disapply. So it means that we have that framing, and it is a framing that the UCC and other jurisdictions stepped off the back of in order to do their work. But it's significant now as you're building these projects. Often we're finding in practice, TradFi firms assume they can work with their existing custodian, but the custodian's not got the MLR registration.
Right.
Or they've chosen a blockchain provider, but not checked if it's got an integration with the current custodian. So there's this kind of jigsaw puzzle where the pieces don't quite fit together. But that Digital Assets Bill, which recognises digital assets can be property, and then goes on to provide us the background to how do you do the legal characterization in relation to the token is the starting point for all of these projects.
Yeah,
I
absolutely.
think that's a critical point, that the UK does have the advantage in that it's observed, it's spent time to watch and study, and whilst quietly confident, I think the rest of the world have looked at the UK and said, oh, you're way behind, you're not a first mover. I don't think that's true.
Yes.
I think there has been a lot done here in the UK. I'm not a UK lawyer. I go on what these gentlemen say about it and observe, and also what Lord Holmes has said. But I think you're right, though. The first thing is to look at it and remember, this is technology. Everyone still keeps getting stuck on the tokens.
Yes.
When actually, if you look at what the technology is, it's underneath that. It's a ledger. Okay, and then start understanding, what does that technology now do to the status of what the token represents? Hence the legal analysis of, well, is it property, is it intangible property, etc. And then starting with that and laying, and that is probably one of the best foundations that the UK have given themselves to launch from. But then actually looking at what has been going on for the last decade or two, because when I attend conferences and listen to people, it seems like they've only just arrived at the table. And that's fine, because it has been a slow growth in certain areas, particularly regulation. But if you go back and look at what people were doing with the technology, there were two kind of angles they had to look at commercially. One is, where's my target audience? In other words, which jurisdiction am I trying to launch my product and service into? And that's where we see the traction of things like Genius Act, et cetera, and MiCA. And then the other one is, where should I base myself right now to get either away from regulation or closer to credible regulation, so that when I do enter into those markets, what am I coming with? So as an example, and I love to hear the status of all these laws and regulations in different jurisdictions. And because I'm from Bermuda, and we actually launched ours 10 years ago. It was about the same time that Malta first came out with some legislation in Gibraltar. But what we did is exactly this. We looked at it and said, okay, we understand the technology. It's a supercalifragilistic, expialidocious ledger piece of technology. What are people doing with it, and why is everybody concerned? What are the problems with this? And it wasn't the problem necessarily with the technology, although I do think it's developed now, and 10 years later we're going, oh, there was better things we could do with it. But you look at it and go, it's what people are using it for. So then we start looking at okay, so if we're going to try and provide some legal regulatory certainty, first of all, what is that? What does that look like? And secondly, can it actually be used to protect our own reputation? I don't know if anybody in the room understands what Bermuda stands for, but it's world-renowned for reinsurance risk. It's the world's third largest capital of risk after Lloyd's, which Lord Holmes referred to, came out of London, is in London, and also the US New York market. And we've been managing risk for almost 80 years, I think. And we've got regulatory equivalent recognition from the US, the EU, and the UK. Now, that's pretty hard to get. I think only Switzerland is equivalent in that status. But what that means is that when we're, as a country, saying we could attract these businesses by providing legal and regulatory certainty, which is what's slowly happening here, but at the same time, do it in a manner that aligns with the rest of our financial system or regulated system. In other words, set a standard that treats these businesses, therefore the people that we're worried about potentially committing or promoting or facilitating financial crime, and make them meet the typical financial regulated standard. So we took it from that approach. We actually didn't care what the token represented. Well, we did, but we didn't define it. We just said if it's a digital asset, it's a digital asset. And the definition is actually not that far off what the UK's landed on. And that just gave us the opening part to say, okay, if it's a digital asset and you're providing products or services to that sector, we need to identify what those are. So it could be custodianship, it could be exchange, could be derivative exchange, it could be payment services, it could be trusts, it could be lending, rehypothecation, it could be broker-dealer, you name it. But if you have an all-encompassing approach to it, which we took 10 years ago and said, we will apply a proportionate or proportionality approach to regulating it, then you're looking at risk-based financial risk management. So, and that's how we've done it. And when people say, "Oh, we're seeing," we see that token issuers might start to be regulated. They've been regulated for 10 years. We've got more regulated token issuers or regulated businesses and digital asset businesses in Bermuda than any other country. 53 at the last count, including Coinbase. which I think Simon, one of the people in the last prior panel, mentioned. And it's places like Bermuda and other jurisdictions, as you've mentioned there, Jonathan, that have already led the way in terms of how can you safely regulate. Different jurisdictions take different approaches. I'm not saying every single one's done it right, but you can certainly take advantage in the UK of looking at where it's been done. Look at the financial crime that has since occurred there, if any.
Right.
And then ask the question, how is that? How is it that still banking and finance are still rife with crime, allegedly, and suffering from regulatory oversight and claims? Whereas where this technology, digital asset technology, has been used and properly regulated, that has not occurred.
Yeah.
And it's the future of, I think, regulation, when the regulators start to go, oh, well, we could use this technology to actually monitor and regulate the behavior.
Exactly. And I think one thing that you really kind of pick up there is about the different roles that sit in and around tokenizing an asset and how it's used.
Yes.
Because I think that early doors with tokenization, we got very kind of caught up in just the representation of the asset. Whereas where the market is now, it's really thinking about, is it a digitally native asset? Is it a wrapped asset? And I know, Jonathan, you had some perspectives on that, on how we've kind of seen that work in Bermuda and other markets.
Yeah, sure. So I think it's important to reflect on what we've just heard, because we've gone from a position in a jurisdiction like this where we're looking to apply the same sort of regulation that we already have in the traditional finance space to the digital asset space. And we were talking about the Digital Assets Act and digital assets now becoming or crystallised as a form of property rights here in the UK. But of course, that gives certain certainties in relation to digital assets, like the legal protections that apply to an asset, what you can do with that from that perspective in estate planning when you're trying to pass on assets in the future, the commercial utility of those assets. But actually, what are these assets? Because there is quite a distinction between something that is a native tokenized asset and something that's a digital representation of a real world asset. And understanding those differences highlights why there are these two fundamentally different approaches that are changing global finance. So just so we're clear, tokenized assets, we're really talking about there a digital representation of a real world asset as opposed to that native form. When it's a digital representation, what you're doing there is you're creating a digital token on a distributed ledger technology that represents that real world asset, but the underlying asset continues to exist in the traditional off-chain world. And so you need to think, okay, well, what laws and regulations apply to that real world asset? And do I need any different laws and regulations applying to the tokenized version of it? And an example of that would be a token that's backed by physical gold or a tokenized US Treasury bill or something like that. The tokenized form of it enables you to trade it 24/7. But it all links back to that original asset. Of course, when you've got a native token, that's something that is created entirely on the ledger. So something like Bitcoin or traditional cryptocurrencies. They don't have a physical counterparty. They don't have a legacy paper trail. So you have to think about how you're going to legislate and regulate for those slightly differently. Because in those instances, you've got the blockchain ledger itself as the golden source. Everything reflects what's on the ledger. The ledger operates its own smart contract. And so it's got lots of benefits: efficiency, modernization of the financial ecosystem, eliminating the need to reconcile that blockchain register with something in the real world, but it still needs to be regulated, legislated for in a certain way. And so two different approaches for those different types of asset.
Yeah, and I think that's a really important distinction. When we look at the US, and the previous panel talked about DTCC, they have been very clear about their path for tokenization. They have 30 trillion that they'll be tokenizing in July, 100 by the end of the year. So the test transactions, the production transactions are happening, and they've been very clear that the legal record still sits at the DTCC. And then the rule books around how those assets are utilised still sit within the existing rule books, be they ISDA, for collateral, et cetera, et cetera. So we have some really good roadmap to see how that works for the UK. But in the UK, you know, Charles, we were talking about the crypto regime and where we are in reality compared to the broader market in the UK. And I know that there are a lot of people in the industry going through the application process. There was quite a drop-off from the last round, and quite a few in the industry that are now moving to different jurisdictions like Bermuda, where you have certainty. So when you're advising clients in the UK, what's your approach, and what do we need to kind of engage them with regards to what the FCA and the Bank of England are driving?
It's an interesting question. So we're pivoting now from, we've been talking about, I think, TradFi adoption of tokenization. So this is the traditional financial instruments and products that are being moved on chain. And in relation to the 10-second history lesson on the UK regime is that the UK applied money laundering regulations to exchange and custody of crypto assets about 5 years ago. The registration process for MLRs, for anything apart from crypto, you fill in a form, you send off a check, and you're on the register. 60 days later, even if you spell your own company's name wrong, we've seen that. The other end of the spectrum for crypto firms, the only filter that the FCA had for crypto in the UK at a time when it had concerns about customer protection and financial crime was the MLR. So there was a de facto authorization process rather than a registration. So we got 59 on the register. Now, if you got on early, you could slide on without too much difficulty. And so the history of these things, of who got on and how, is interesting in itself, as you say. A lot of people didn't make it, and some of the large exchanges took a long time to get onto the register, and a couple not there yet. Some still going through the process, and others not. So we're now going into a new regime where these assets are not simply subject to marketing and financial crime rules. They are treated as financial assets inside the regulatory perimeter. So that is an enormous shift. The uplift, as everyone euphemistically refers to it, is something like going from an exchange to a bank. So it will be potentially extraordinarily expensive. And folks like us are working through this with the firms who are on the register. Have you made the decision to apply? If you're a global firm, are you using a subsidiary structure or something else? If you're a UK firm, are you in good standing with the FCA? What business are you doing? So there's a mapping exercise of activities against, bluntly, revenues. Is it worth it? If you're going to make £10 million a year serving UK customers and it's going to cost you £20 million to do it, then you won't. This is, I think, the most significant question that we've got, that if 59 shrinks to a handful or less, that will be politically embarrassing. So,
sorry to interrupt. Is there no sandbox? Is there no gradient? It's just you're this and that's it. I'm just listening to Lord Holmes earlier about
more or less that. Yeah.
Okay.
And not only that, there's quite a delay, right? Getting through the applications. There's not a lot of certainty. The path to revenue is still 18 months away for all of that investment, right?
Yeah.
When there's many other choices.
Yeah, and usually for crypto, it's always been the case that you need to have be burning a lot of investor money going through the UK process. You've got to have all the people and all the systems in place before they look at you. With other regulatory permissions, you can be building and adding as you go. Wow. So the timeline is from October. People have got a window through to February to make the application. So everyone is scrambling right now to get themselves sorted. You can have a pre-application meeting with the FCA, and we would encourage everyone to do that. I think the FCA is now in a slightly different place. It was relatively unsupportive of a lot of crypto business at a time in the past, and now it's much more supportive. I think there is a sense that firms migrating to other jurisdictions has meant that we've lost some revenue from the taxpayers.
And liquidity, right? We used to be a liquidity hub, sorry.
No, I was going to say, are they migrating or are they temporarily getting themselves ready? Because what I've seen over the last decade is businesses, going back to the point I made about, yes, target audience is critical, but actually where can I build and get to revenue much quicker? And so I've seen companies come to us to get regulated and use us as the will service rest of the world. In other words, where it is not illegal, prohibited or otherwise regulated to offer that product or service, we can get going now with a credible regulatory regime that mirrors traditional financial institution requirements, and then get to market and revenue.
Right.
Because you don't need, in Bermuda, you don't need everybody in place before you make the application, but you've got to have it all in place before you get your license. So it allows this slow or sort of intermediary steps to get there. And also we have Class T, which means you can come and test the process and limit yourselves, I don't know, 50 million or something, and then a sandbox, and then a fully fledged license, which means that when you then look at, say, the UK or MiCA or elsewhere, you already have revenue, you already have a proven product, your technology works, and even a brand. You know, all these things that then help you, we've got the people in place and they're actually paid for.
So
the political challenge would be, that would be fine for the large global exchanges, and they've got the money. If you spend enough money, you'll get the permissions. It's as simple as that. For the domestic firms, most of the 59 are international. There are some TradFi firms, there are some hybrid firms. There is a core group of UK firms that shouldn't be, from a political perspective, that shouldn't be the right answer for them, that we're saying that they should go elsewhere and then reverse back in. It's not how they were, how they built their businesses. So I think one thing that the FCA has been quite strong on for exactly this reason is that they will apply the rules proportionately. So the best commercial approach may be to shrink your business, shrink your product, shrink your customers, do a land and expand model in the UK. So all these conversations are essentially, we're in the middle of tens and tens of these conversations, and everyone's in a different position.
But also for the largest and most sophisticated financial institutions who need the big pools of assets in the UK, the EU, the US, and elsewhere, I mean, they have to adapt. So and they can see that the adaptation means applying TradFi regulation to TradFi activity, but also in the UK, this new FCA crypto asset perimeter that's applying to the technology rails you use, how you custody those assets, how you transfer those assets. And they appreciate they're now going to have to deal with both regimes or work out whether they are just in one or just in the other. But I think for most, it's going to be a combination of both regimes, which doubles up the expenditure, which means that perhaps over time in more heavily regulated jurisdictions like this, only the most sophisticated revenue generative businesses will survive.
Actually, on that point, there's that fear of double or even triple regulation, and we see it more pronounced in the US because you've got various different regulators looking to get it. It's less pronounced now, but it was quite phenomenal a few years ago. What we've seen is where if the regulator can look and see that there is similar risks because of the product service, and at the end of the day, what are you trying to regulate? Human behavior or person behavior, legal person, that they can actually streamline it. And so we've got an approach where if you are already licensed in one financial regulatory sector, state reinsurance or insurance, and you want to go and tokenize that, so tokenized insurance-linked securities, then that's fine. You don't now need to go and get a digital asset business license, but the codes which we've developed over the last decade, which apply to the risk, cyber risk, and requirements of maintaining registers and underlying assets, insurance and other likes of coverage, as long as you apply those codes to your business, you can continue and you can do that activity. So I think it's certainly something that the UK should be looking at in terms of not building something that is so too sector focused, and actually say, look, if the risk is the same, either as what already exists or as another tokenized product, then we should be mirroring that and aligning it and streamlining it. But I don't deal with the regulator here, so I don't know what their approach would be.
Yeah, I think so. The UK is somewhat helped in timelines by the fact that most of these are international businesses facing Europe. So we've taken them through the VASP and the CASP in MiCA. The UK considers itself, for obvious reasons, a high standards regulator, and it won't apply even de facto passporting. You're kind of starting from scratch. There are, I think, some very positive stories in the TradFi use of tokenization, and there the regulator is much more comfortable. So if you're already supervised, and you have been for a long time, they're extremely supportive. And partly on purpose and partly by accident, I think the UK will be a strong global home for TradFi going on chain.
Yeah.
It will be for crypto native businesses. And we had the announcement yesterday. Bailey Gifford publicised their natively tokenized fund. So there's a lot of support from the regulator to get that launched and off the ground. And the Investment Association, you can see in public statements, is following up on that with the support of the regulator, plus Treasury, plus so on. So that the UK regulators and Treasury, they know what they'd like to support. It's the IT uplift for TradFi.
With the operationalization, how do they get that going?
Yeah, I think crypto native is more challenging, and we will be a later mover on that.
Yeah, but the rubber hits the road, right? Where you have an asset that's tokenized, you get it in the right jurisdiction, to your point, where we have the certainty. How do you manage the perimeter, the regulatory perimeter between a tokenized asset, be it native or digital, that gets utilized for collateral in a secondary market, because it's often 24/7 markets that it's being utilized for, and settled with a stablecoin? So we're kind of crossing the streams here, and that is honestly like day in, day out what I hear from clients.
Do
I issue here? Where do I issue?
You're creating a completely new economic platform. With assets that people haven't thought of how to regulate.
That work together.
And they work together. And this almost goes to the decentralized point, which, again, I think was mentioned on the earlier panel. And everybody seems to be terrified of it. And they don't need to be terrified of decentralized finance, because it's been around for a long time. And at the start, people didn't really know how it fit. Again, it goes back to the correct approach that the UK has taken. Assess what you're doing with the technology. Look at the behavior that needs to be regulated and understand how to do that. And if we just talk about for the moment, decentralized finance, most of those projects sought to not seek legal protection, as in limited liability, by creating a company or an organization that then launched it as a product. They wanted it to be completely autonomous. That was part of the benefit and the ideology behind this. And where the right regulators are looking or analysing it is they're saying it's not a legal person. What is regulation and law? It is man-made, man-created, or women-created, women-drafted, I should say, sorry, to be politically correct these days, to motivate and incentivize behaviour. And in that world, you don't have those persons to regulate. So effectively, a properly decentralized autonomous organization cannot be regulated because it's not a person. But the people in and around it can be. It's like the internet in a way. I remember when the internet first came around, yes, I'm that old. Bermuda does me a lot of good. There were academics that were saying this internet, this sort of surreal world out there, everyone's going to be jumping in and being criminals because there's no law or regulation that can kind of has jurisdiction there, and until they realized, oh, wait a second, no, it's us, people and persons and legal organizations that are interacting across what is the internet. It's a method of communication and interaction. And so it's not the internet that per se needed to be regulated. It was, again, technology. It's the people. And so there wasn't this world of criminality. Yes, crime occurs on the internet, and crime can occur with use of technology. But the regulators need to get on board and realize that the technology can sometimes be the answer to those problems. And I find it amusing that a lot of the TradFi are slowly looking at this going, oh, we could use this technology to enhance ourselves. We're actually forgetting about what this thing could do to actually enhance the regime.
The entire market. Yes. 100%. And I think we talked in the prep about the operational commercial risk. And I think what you've just described is a lot of the kind of TradFi people kind of copy pasting the current, differentiators they have into a decentralized way, which isn't getting the best out of the technology. And we haven't yet
Comes with risk.
Right. So we haven't pressure tested the risk. We haven't pressure tested the commercial, the systemic, all of those things. So I know, Jonathan, you had some perspectives on that, because actually that is what clients are asking of you today.
Yeah, sure. Well, whether it's DeFi or TradFi operating in the digital space, there are real risks that need to be thought about. If you're operating autonomously using smart contracts, there can be technical failures in those smart contracts. How do you deal with those? How do you deal with the executable costs involved in a failure of the technology? How do you deal with the idea that you might need to apply some subjective discretion to certain aspects of a contractual regime? And how is that dealt with on smart contracts? A lot of thought that's gone into that, but we're not quite there yet. Enforcement across jurisdictions is still really uncertain. Which law applies, which governing law applies, what jurisdiction applies from a dispute resolution perspective, particularly in circumstances where there may not be a particular jurisdiction that is sort of the directing mind of the activities that are going on. And that's the whole idea of DeFi, is that the contract is anywhere and everywhere. We've talked about the regulatory classification, and that continues to evolve so much. If you go down the route of thinking that you are really comfortable with a particular regulatory regime, that can change, or there could be a better one coming along in perhaps a more heavily rated, more regulated, more sophisticated jurisdiction in the future. And we still don't quite have that liquidity available, particularly when you are exchanging assets between one system and another. The interoperability of different systems remains a real problem in this industry.
It really does.
So there's a lot to be thought about, which is perhaps why we as lawyers end up doing so much work at the moment on this.
Yeah, and I think the word interoperability is kind of used as a catch-all. There's quite a lot of layers to what makes interoperability work, probably not helped by the tech platforms that are trying to push their own protocols and their own definitions, etc. Charles, I know we had a conversation about the interoperability approach and how you can think about it practically.
Interoperability is hard, and the bridges is where the hacks are.
Yes, that's right. That's right.
My colleague Erica's on a panel this afternoon, and she's very famous for saying that people should spend more on security. I think my original background in crypto is DeFi, so I have to be an apologist for it. And I think it's still experimental, and I think it has suffered from having the focus from financial regulators. We're very comfortable with open source software in every other part of industry. So I think that mind shift where the regulators do want a person to be responsible is significant. The use of decentralized protocols by TradFi firms is easy. They will be responsible. We know exactly what the regulators are looking at. They're obsessed by gas fees.
Yeah, okay.
Ensuring that there's budget to pay.
Curious, why is that?
Because this is something that they're aware is a variable cost that should be borne by someone, and from their perspective, it shouldn't be borne by the end users.
Okay.
So there's a relatively short and well-established list of what the regulators are concerned about when you're doing tokenization projects. I think what we've seen the success in, the reason it took time for tokenization of funds, it was an odd choice for the for Treasury to push on, but it was a political choice that the UK had a lot of fund management firms in it, so that was a focus. But the things that get tokenized first are the most liquid things, because they're the easiest to manage your risk in.
To get in and out of, yes.
It was cash, and we can now see stablecoins is looking like the first killer app that we've had in crypto. There was no digital cash leg for tokenization of funds. Now there is. Right. So that's why we're at the races.
And you can get the collateral moving because you can actually settle outside of market hours.
So these things have to fit together. we'll all be working on tokenized deposit projects now, and they are different. The Bank of England was very concerned about deposit flight, and to be fair to it, it's updated in the last couple of days, lifting caps and things like that, as the other panel were talking about. They get it. They've listened to industry, particularly the buy-side industry, saying we wouldn't build this if it's only going to be sandboxed, and we can't see the scale that we're going to get.
Right, so just issue and sit.
Yeah, it starts to work together. The experience has shown that there isn't deposit flight when you tokenize, when you have stablecoins and you support stablecoins. So we've got Simon Taylor's framing, I think is very good.
Yes,
tokenized
very pragmatic,
digital money at rest and stablecoins, digital money in motion. That explains it, I think, really well. And
does that give people in the room something practical to start thinking about and start advising? Because every day they would have clients coming to them saying, how do I approach this?
Yeah, I think
market?
The first question we ask all the projects is, do you want to do something that's never been done before, or do you want to do something that has been done before?
Great start.
That's a cultural question.
Yeah.
The crypto native projects are trying to innovate. They're founded by engineers. They're full of engineers. If they didn't an early ICO, they're still giant piles of money.
Yes.
They're trying to get adoption on their chain.
Yeah.
And anything that kind of pulls that in, they want to be first, and they will respond to what each other are doing. The most significant thing in the global economy at the moment is attention, and that's what we're seeing in prediction markets and sports. The best job these days is sadly not being a lawyer; it's being a professional athlete. It's the only thing.
Or an AI builder.
AI builder.
Yeah.
So the flip of that is the TradFi firms who. I mean, it's not a coincidence that in the UK, the leading firms on the buy side were BlackRock, Fidelity, and Franklin Templeton. So 3 US firms, 2 of them privately owned. This is hard to do. You need a bit of a run at it. You need cultural support. You need senior support. But now there are models that you can follow. If you want to do tokenization as a buy side firm, you're not having to build everything from a blank sheet of paper. I guess the other thing is working down the list of most liquid assets. We're now seeing it in private credit. So I think private credit and securitizations is the next big push. They were early stage projects through 2025. They're scaled projects this year.
And you see it with permissive regulation really helping the industry to gain momentum. We talk about those fund managers that started off by tokenizing money market funds because it was one of the simpler things to do, albeit still complicated, but also something that regulators said, well, actually, tokenized money market funds is something that you can use as collateral to support your derivatives transactions or your securities financing transactions. And that will be recognised under the key regulatory regimes like EMIR. And suddenly the fund manager said, oh, wait a minute, it's not just a case of issuing these money market funds in a tokenised way. We can apply them as collateral. We can have instantaneous, perhaps in future, atomic settlement in relation to them. It reduces so much friction in the collateral movements around that, and we can have so much more efficiency in the work that we do for our clients.
Yeah. So
that goes to the point about what the designers, the coders, need to be thinking about. And I've heard this repeated for the last 2 years. Wherever I've gone in the world, it's the same mantra. And that is that the natives, the people designing this stuff, have to understand that they need to design it in a way that allows the users, which is the TradFi world effectively, to remain compliant. Those regulatory requirements, financial requirements, collateral requirements, corporate governance requirements, AML requirements, they're all going to stay. It's does this technology and what we're using it for and creating these new markets and new use cases, is it designed in a way that will facilitate and ease the way in which we have to do that? I mean, client onboarding, one of the most friction areas of my business still today. And we've got a bank in Bermuda that's managed to convince the regulator that actually doing digital onboarding, i.e. over a video call with verification of IP address and the documentation that's shown and I'm a live person and I look like my passport and all the other things that go with it, and I don't claim to know exactly how it works. even though I'm a tech lawyer, I don't understand most of the tech. But that is far more secure than having somebody walk in and give to somebody at reception a copy of a passport and a utility bill and have them photocopied and certified true copies. Thanks very much. Off you go. See you in 2 years. And it's that kind of approach. As they develop these and as they're thinking where the use cases are, and I think as lawyers, it's incumbent upon us to recognize when we have those projects come in, and we look at our clients who are effectively technologists, but because the technology allows them to create new financial products, going back to the original point, suddenly you've got tech companies that are now financial institutions. And it's where's that balance? And making sure the tech's developed in a way that it's going to meet that criteria.
And bringing them together, right? Because actually a lot of the innovation that you just described has been brought in by tech natives, but needed the kind of more traditional perspective on how to apply it. In practice. And I think where we've seen things really work is where those two worlds come together, not TradFi, not DeFi, where they sort of co-design some of those things together. When we first started this whole thing, the DeFi natives were like, oh, we're not going to need a custodian. Guess what? TradFi banks want custodians. They don't want to do that, not for the reasons of, the inefficiency, just because that's not their core job. And I think the practicalities of applying the traditional world in a DeFi way is really where we need to get to.
And let's not forget, as human beings, and again, one of the speakers on the other panel, I forgot the one from NatWest, and his Tezor, USB. I agree. I've got a plethora of apps and technologies and hardwares that I'm testing for my clients. I use it so that I can understand what they're trying to achieve, so I can then apply the law to it and see how it works and what they're actually doing. But there is this thing about human nature. We seek to trust. Most people don't understand the technology and are terrified of it. And I'm one of those. I would much rather trust somebody and give them some sort of fee, but knowing that they're liable. If they mess it up, I want compensation as a consumer. But I trust you to do it. And yes, as a stablecoin holder, you can go and take the actual currency that I had, and you can go and make money out of it, like what Tether was mentioned, 800 billion a quarter now, profitability. The most profitable company in our lifetime using this technology. And it's about understanding that as humans, we do seek trust. Even though this technology is phenomenal, one of the best parts about it is peer-to-peer. But the only peer-to-peer stuff I ever do is buying from a merchant. I'd like a can of Coke, please, or I'd like a beer, please, or my Sainsbury's. Whatever it is, I'm just buying something off somebody else. That's us. Go into the real financial world and we're dealing with trust issues. And the whole point of having all these custodians and the whole point of the regulation we have in the TradFi world is because before that it was criminal. There was criminal behavior, there was theft, there was all of that. That's what it was there to protect.
But that's what's potentially so transformative about legislation like the Digital Assets Act in the UK, and saying, okay, no, this is property, this has rights, therefore you can create a trust over it. You can see how it sits in your insolvent estate. The risk, though, is that the courts might come along and say, oh, this is a new area of property. We now need to develop a whole new line of jurisprudence to determine how you apply a trust over it.
Hasn't been tested.
And how different is it to the assets that we've seen in the past? And so there's still quite a lot of evolution to come to see how both legislators, regulators, but also the judiciary in so many key jurisdictions will apply the new law.
And actually, that's the point that a lot of people are missing. Is it's all well and good for us in the UK to say it is property, it's an intangible third right or whatever. But if everybody else in the world disagrees, and the US is a very good example of disagreeing with most things in the world when it comes to law, it's their way, or the highway, for good and bad reason, you don't have alignment. And we are going from a globalized economy into a very fragmented
100%.
one. And whilst this technology has the ability to re-globalize everything, we've got to remember that laws are jurisdictional.
That's right.
And you will have instances where maybe if it was debated and looked at jurisdictionally in England and Wales under our laws, you've got to think about, okay, well then when we set it up, let's make sure that those laws apply and try to ensure that no other jurisdiction or court has jurisdiction, over it because of the lack of foresight in embedding that in.
Yeah.
What was it that was on the... Was it on the Bank of England? No, somewhere by bank, there's a sign and it says 40% of all commercial contracts are subject to English law.
Yeah.
Which is fantastic, but
Right.
it's still that way today. That's obviously from our shipping days, I think.
Right.
But,
So we have 24 seconds. Well, if everyone can
Wow.
give us one practical insight that you would give to the audience that they should do after leaving today, and then an ask of the regulator that would help us move forward. Jonathan.
Sure, okay. One practical insight for people in the audience, I would say, think about why you are using a tokenized version of an asset. What is the use case? And then you can think about how it's going to be regulated and what laws are going to be applied to it. But what actually, why are you doing it? Don't do it for no reason.
Mm-hmm.
For a regulator, I think I'd say the mantra for so many people, same activity, so same risk, same regulation.
Mm-hmm. Charles.
Okay. Listen to the clients. Too often the private practice lawyers are trying to push the service onto the clients that they have. It's if you went into a shop and asked for a blue jumper and the person in the shop gave you a red cardigan and said, well, it'll cover you and it looks nice, you wouldn't accept it. Listen to the clients.
Steve.
I would say go and get the GLG publication out there on fintech or cryptocurrency and blockchain, because it actually has examples of the jurisdictions around the world that have already done this. And have a look at those. I appreciate people might want to do everything in the UK, but the point goes to, have you got enough runway and money to do that?
Yeah.
And if not, then you can start somewhere else whilst continuing to build in the UK. So go and read that first of all and see what has been done elsewhere. To the regulator, exactly the same thing. Go read that book and that chapter on everything that's been done elsewhere. Observe, learn, and not duplicate, but take the best of it and apply it to what's going on here. And I totally agree with my fellow panelists that, it's almost like don't get out of the way, but get out of the way.
Right.
Look at what you're actually doing here. Well, what are we actually regulating? Same behavior, same risk, etc. And enhance the environment for people to innovate. Goes back to what Lord Holmes says. Innovation and regulation do coexist, and in fact it's going to be more coexistent going forward as the regulators use the technology and innovate themselves.
That's right.
Can I make a very quick addendum?
Jump on.
Which is the beautiful thing about crypto firms. If you work for TradFi firms, they want there to be a rule saying they can do something before they do it. Crypto firms, if there isn't a rule saying they can't do it, then they're doing it.
They're pushing it, yeah. I just want to jump on your point, Stephen, about getting hands-on on the technology and kind of circling back this whole panel discussion. One of the things I've personally learnt myself after launching networks is until you're actually looking at the data and looking at how the data moves on the ledger, it's very hard to understand. And so where I'm seeing this work is where people get hands-on with the technology, like you say. So if you're advising clients, ask if you can have a guest or a ghost node. I know a lot of the TradFi firms that don't hold assets are doing ghost node observations. And the regulators are also doing that for the big transaction flows. So that would be, I think, a really good way forward. Thank you so much, everyone.
No, thank
Such a
you,
good
Liz.
discussion, and I hope you enjoyed it.
Thank you very much. Thanks, Charles.